Hello YouTubers, my name is Genaro Cortez. I'm a San Antonio criminal defense attorney, and today I want to talk to you about federal drug crimes. Specifically, I want to answer the four most common questions I get in federal drug cases. First, what is a federal drug crime and how does it work? Second, what does it mean to be in actual or in possession of a drug? Third, what is a drug conspiracy and how do you get out of one? Finally, how does substantial assistance and safety valve work? So let's get started. Possession with intent to distribute is a federal crime. 21 U.S.C. section 841A1 makes it a crime for anyone to knowingly or intentionally possess a drug with intent to distribute it. Now that one sentence carries several key facts or elements that prosecutors must prove. There's actually four things they have to show. One, that the defendant knowingly possessed a controlled substance. Second, that substance was a drug like cocaine, heroin, or meth. Third, that the person possessed it with intent to distribute it. And finally, the drug quantity. The drug quantity is key because that will trigger the mandatory minimum sentence in a drug case. For example, 5 years or 10 years, depending on the drug quantity and the drug type. Now, possession with intent to distribute is a legal term, but it simply means to possess a drug with intent to deliver it or transfer it to somebody else with or without any financial interest in the transaction. So what does that mean in a nutshell? It means you can be guilty of possession with intent to distribute even if the drugs aren't yours and even if you weren't getting paid for it. On top of that, prosecutors can prove intent to distribute easily. They use facts like if there's a large amount of drugs involved, if the drugs are expensive, or if they find drug paraphernalia near the drugs like digital scales, baggies, twisties, or drug ledgers. Now let's talk about drug possession, the definition. Drug possession can be either actual possession or constructive possession. Actual possession means a person who knowingly has direct physical control over a thing at a given time. In contrast, constructive possession means a person who does not have actual possession, but nonetheless knowingly has both the power and the intent at a given time to exercise dominion or control over the thing, either directly or through another person. Right? So let's say that in plain English. Now the video playing in the background is a video of former president or the late President George Herbert Walker Bush giving an address to the American people from the Oval Office. In his hand, he's holding a bag of crack cocaine that was seized in front of the White House. And so when he's holding it up, that is actual possession. He's got physical control over the drugs. Now, if he had his Attorney General hold the drugs for him, then he would be in constructive possession of the drugs. But the key to possession are two. There's two keys to possession, two key facts: knowledge and control. You have to know that there's drugs involved, and you have to have control over them. If both facts are present, then you're going to be in possession of the drugs and likely guilty of possession with intent to distribute. So now let's talk about federal drug conspiracies. 21 U.S.C. section 846 makes it a crime for anyone to conspire with someone else to deal drugs. It's basically, drug conspiracy is basically a partnership in crime where each member of the drug conspiracy becomes the agent of every other member. So for example, if person A has a kilo of cocaine and he's in a conspiracy with persons B, C, D, and E, persons B through E are also going to be liable for that kilo of cocaine because they're part of that conspiracy. And that's what a drug conspiracy is. In a nutshell, it's a deal between two or more people to deal drugs, and each one is responsible for the other's actions. One of the things about drug conspiracies is it's actually a different crime from possession with intent to distribute. That means it's common to see indictments or people charged with possession with intent to distribute the drug and conspiracy to possess with intent to distribute the drugs. This gives prosecutors powerful weapons to go after drug traffickers. And that's what a drug conspiracy is. Now that we know what it is, we can also talk about how to get out, how to withdraw. to get out of a drug conspiracy, if you're in one, you have to tell the people, your co-conspirators, you've got to explicitly tell them, I'm out. I don't want to do this anymore. Don't call me again. I'm done with this. Okay. You can't simply just walk away. You have to tell them you're out. You have to take affirmative steps to show that you're no longer involved in that partnership in crime. And here's why you want to do it. When you get out, it's a cutoff point. It doesn't absolve you of what you did when you got everything you did before and during everything you did before the cutoff. So whatever you did from the start of the conspiracy until the point you got out, you're responsible, and that means you can be prosecuted for what happened there. But everything that happens afterwards can't be used against you because you've withdrawn from the conspiracy and you're no longer a partner in crime, and those people are no longer your agents. And you do that, and it helps you in two ways. For example, let's say I'm in a drug conspiracy, and today is June 29th, 2022. And I tell everybody, you know what? I'm done with this. I'm gonna go straight. I'm gonna be legit. Don't call me anymore. I'm done with you guys. And then 5 years and 1 day from today, the prosecutors file an indictment, and they charge me with conspiracy to deal drugs. I can raise the affirmative defense of withdrawal. I can tell the prosecutor, the judge, and the jury, yeah, you know what? I may have done drug deals before, in those 5 years before, but I got out. And you guys filed the indictment too late, okay? And therefore I shouldn't be charged with this crime because the statute of limitations applies. That's one reason to get out. Another reason to get out is even if they file the indictment within the statute of limitations, you can argue at sentencing that the drugs that were dealt after you got out shouldn't be used against you to increase your offense level or your jail time. So that's how you get out of a drug conspiracy. That's why you're going to want to get out of a drug conspiracy. And I advise all my clients, if you're in it, get out. Nothing good's going to come out of it, and that's how you do it. Now let's talk about safety valve and substantial assistance. And the sad truth about drug cases is this. Most of these drug cases result in a plea bargain or a plea deal. And the reason is because the evidence against them is usually pretty strong. Not in every case. Now, I've tried the drug cases before, and I'm not telling you not to fight your case. But part of what I'm telling you is, in a majority of the drug cases that I see, people want to plead out, and it's not me telling them to do it; it's them reaching their own conclusion. And it has to do with looking at the evidence. If there's text messages connecting people to the crime, if there's confessions, if you're selling to undercover officers, if there's informants or co-defendants that flipped and are now informants or snitches. These are the types of evidence prosecutors have. And if they're present in your case, put the snitches aside. If there's an undercover officer testifying against you, or if you confessed, those are two really strong facts that may want to push you to work something out. And then when that happens, the next fight becomes, how much jail time do you get? And that's the biggest fight in a drug case, is trying to get the sentence as low as possible. And to do that, you need two tools, or there's two legal ways to do it. One is a safety valve, and the other is substantial assistance. I've written about these before, and I'm going to include a link to my blog post on that below. So click on it and check it out for the details. But in a nutshell, they both require you to cooperate with prosecutors. You've got to tell them everything you know about the crime if you want to qualify for safety valve. And on top of that, safety valve has some limits to it. You have to basically have a clean record, more or less. No more than 3 or 4 criminal history points. And you also, the drug deals must have been just pure drug deals. No guns involved, nobody was hurt or killed during the drug deals. It was you just giving drugs to somebody else. If you qualify for safety valve, then what happens is you can ask, it'll help bring down your jail sentence, but more importantly, it will let the judge, if he wants to, it doesn't mean he will, but it'll let him give you jail time below the mandatory minimum sentence. So that's really a powerful incentive for people to cooperate. It helps lower your jail time. In contrast, a 5K motion, substantial assistance motion, it's up to the prosecutors. So you basically have to tell them everything you know, and if they think it's helpful, then they'll file the 5K motion. And sometimes you tell them everything you know and it's not helpful to them, so they won't file the motion. So that's one of those things that's one of the differences between a 5K motion and a safety valve. In the safety valve, even if the information is not helpful, but you tell them everything you know and you meet all the other requirements, you can still get the safety valve. In contrast, the 5K motion, if the prosecutors say it isn't helpful, then you don't get the 5K motion. But the 5K motion doesn't have the limits that the safety valve has. For example, there's no criminal history point limits, and if the crime if you had a gun during the drug deal, or if there was violence, that won't disqualify you from the 5K motion, but you have to have substantial assistance. In other words, the prosecutors have to say, you know what, that information you gave us was really good, and as a result, we're going to move for a 5K motion to drop your sentence. So that's basically safety valve and substantial assistance in a nutshell. And the key is they help you lower your jail sentence if you plead guilty. And you may qualify for safety valve even after if you go to trial and lose, but it gets tougher, and the prosecutors are more likely to oppose it than if you work something out with them. And so that's what you need to know about federal drug crimes. If you have any questions about this video, or have suggestions about future posts, shoot me an email at info@cortesdefense.com. I enjoy hearing from you guys, and I'm happy to talk about whatever it is y'all want to talk about. Finally, if this information is helpful or useful, don't forget to click the like link below and subscribe to our channel. Thanks for listening. Until we meet again.